per State versus Lemire, where discovery violations inject needless delay into the proceedings. Dismissal with prejudice is warranted to ensure the integrity of the judicial system. Your motion to dismiss with prejudice is granted.
So one of the biggest lies that I hear about in the legal system today is that the judge can actually throw out a case after hearing the circumstances of it.
You know, my guess is the people watch TV, right? And those judges listen to both sides and go, you know what? I think you're right. Or, you know what? I don't think you have a case. That's not how it actually works, though, in our system, is it?
Right. Our system's a lot more formal than that. It's going to start with the charge itself. Then there's going to be a formality like arraignment. And then you're going to go to pretrials. And what's hard to believe for people is that at those pretrials, while we're still gathering the evidence and conducting discovery, the judge actually doesn't hear any of the case, right?
Yeah, judges are not the finders of fact in criminal court. That's a jury's decision. So if you want to be able to argue that the other side doesn't have a credible statement to make, or they're lying, or something like that, the only person who's going to make that determination is a jury, the finders of fact. The judge's role is really just the referee who says what laws apply in a case. And that role really doesn't come into play until trial. When people think that a judge is the one who's making the determination, they're misunderstanding the role of the judge. In fact, it's the prosecutor who is the one who has to make that decision. So when we as lawyers are trying to present information before trial in order to convince somebody that, yeah, in fact, this guy's lying through his teeth and the case you have isn't a good case, we're not talking to the judge, we're talking to the prosecutor.
Right. And then if the prosecutor doesn't listen, sometimes the only way you can get someone to listen is to take it to the jury, take it to a trial.
Right. There's really no point where we can come to a judge and say, Judge, here are the circumstances. Judges learn about the case at trial by listening to the evidence. And it's not until, unfortunately, people are convicted that then you have to present to a judge the argument of, hey, here's what's really going on, here's how you should treat the person. But the judge is not going to make the decision.